What type of physical injury is required for criminal assault in New York by criminal defense attorney Andrew M. Stengel? Part 1. An overview. There are 3 degrees of the crime of assault in New York. Both assault in the 3rd degree and several kinds of assault in the 2nd degree require a prosecutor to prove that another person sustained a physical injury. The term physical injury is defined in the law as impairment of physical condition or substantial pain. In New York, physical injury is required in assault in the 3rd degree and a few types of assault in the 2nd degree. Prosecutors also have the option to charge an attempted crime where physical injury is required. This occurs when there may be evidence that a person intended to cause a physical injury but failed to do so. Assault in the 3rd degree, which is a Class A misdemeanor and punished by up to 1 year in jail, is charged in 3 situations. With intent to cause physical injury to another person, he or she causes such injury to such person or to a third person. He or she recklessly causes physical injury to another person, or with criminal negligence, he or she causes physical injury to another person by means of a deadly weapon or a dangerous instrument. When is physical injury required to prove assault in the 2nd degree? Assault in the 1st degree is a Class D violent felony and carries a mandatory prison sentence for a first offender, usually between 2 and 7 years, but the prison sentence could also be less. A few kinds of assault in the 2nd degree require a physical injury, including intentionally causing a physical injury with a weapon, intentionally causing a physical injury to certain categories of people, like a police officer or MTA employee, intentionally causing a physical injury to a person who is less than 7 years old if the actor is at least 18, or intentionally causing a physical injury to a person who is at least 65 years old if the actor is at least 10 years younger. What is a physical injury? The typical claim in criminal cases of where physical injury is required to prove the crime is that a person caused bruising, swelling, a laceration, or substantial pain to another person. Substantial pain is anything more than slight of trivial pain. Courts have held that bleeding, bruising, and swelling for which a person required medical attention is considered a physical injury. Courts have also held that a bump and/or a bruise with resulting soreness is a physical injury. Treatment by a medical professional, whether an EMT or a doctor, is not necessary to prove a physical injury. What is not a physical injury? In New York, courts have held that a physical injury pain requires more than slight or trivial pain. Petty slaps, shoves, kicks, and the like delivered out of hostility tend not to fall under the definition of a physical injury. The mere claim that a person was caused substantial pain by being shoved or hit may not be enough to show a physical injury. Courts may also consider the ability of a person to perform certain tasks to determine whether or not there was a physical injury. What is a serious physical injury in New York? In New York, serious physical injury is defined as a physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. A serious physical injury is usually far more severe than a physical injury. Wounds from weapons such as knives may not constitute serious physical injury if the wound is only superficial. However, a physical injury caused by a weapon may lead to the charge of assault in the 2nd degree. When is serious physical injury required for assault in the 1st or 2nd degrees? A few kinds of assault in the 2nd degree require a serious physical injury, including intentionally causing a serious physical injury and recklessly causing a serious physical injury with a weapon. Assault in the 1st degree is a Class B violent felony and carries a mandatory minimum prison sentence for a first offender of between 5 and 25 years. 3 of 4 kinds of assault in the 1st degree require a serious physical injury. Intentionally causing a serious physical injury with a weapon, recklessly engaging in conduct that creates a grave risk of death to another person and causing a serious physical injury to another person, and in the course of the commission or attempted of a felony or of immediate flight therefrom, causing serious physical injury to a person other than one of the participants. Can a prosecutor prove a physical injury without a complaining witness? The short answer is yes. A person could be convicted of assault without the trial testimony of the complaining witness. Even if a complaining witness does not testify, evidence introduced at trial may support a conclusion of substantial pain. Evidence such as surveillance video, 911 calls, the observation of witnesses such as police officers, and statements to medical personnel may be admitted attempting to prove a physical injury. This evidence would also be included in a trial with the complaining witness who testifies. Even if there isn't enough evidence to prove a physical injury without the testimony of a complaining witness, the evidence could still lead to a conviction of an attempt to commit the specific degree of assault. As a former prosecutor and current criminal defense attorney in New York, Andrew Stengel has aggressively and successfully handled hundreds of prosecutions for assault. Visit the website of Andrew Stengel for more information, STENGELLAW.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.